Commissioner Holzman here.
Oh, thank you, Commissioner. Looks like you're calling number 4.
Hey, Judge, I've got pretty bad service where I'm at, so if I drop off, don't worry. Okay.
Okay, thank you. And I'm kind of waiting to see. I thought someone from IT was gonna web stream this for me.
Judge, I'm here. We're streaming.
Oh, okay, Justin, I'm sorry, I didn't see you. Okay.
Oh, you're
thank
fine.
you.
I just kind of snuck in under the radar.
Okay. And I've got a couple more people on the phone. I don't know if you can see, but someone is calling user number 5. Can you identify
Commissioner
yourself?
Kenny.
Commissioner
Commissioner
Kenny.
Kenny, sir.
Thank you.
Judge DePel, this is Natal. I had to recall in, so I'm not sure I show up as the same number or a different number.
Okay. Yeah, it looks like you're number 5 now, and Commissioner Kenny is number 6. So. Just trying to identify everyone, so help our court reporter keep things straight. We'll give it just a couple more minutes before we begin officially. Let everybody get logged on. I'm going to give it just a couple more minutes and then we'll get started. I think we have most of everybody that's going to join us. So it's after 10, so we'll go ahead and get started. Bev, are you ready? Okay, thank you. Let's go ahead and go on the record. This is case number WU-2020-0417 in the matter of the application of Missouri American Water Company.
Please leave a message or try me in my office at area code 573-751-4132. Thank you.
At the tone, please record your message. When you've finished recording, you may hang up or press 1 for more options.
There we go. Okay, I think we got her on there now. Let's go back on the record. Sorry about that. So this is in the matter of the application of Missouri American Water Company for an accounting authority order authorizing it to defer and accumulate costs and financial impacts related to COVID-19. My name is Nancy DePel. I'm your regulatory law judge presiding over this matter. And we're here today via WebEx video and telephone conferencing due to the COVID-19 pandemic precautions. This proceeding is being held to hear, have a presentation about the stipulation and agreement. And it is being transcribed by the court reporter, and the audio is also being streamed live over the internet through the Commission's website. I'd like to ask everyone, if you haven't already, to please mute your phones or other devices, and unless you're speaking. And also, if you could be sure and if you're on a phone and we don't have your name specifically, it helps if you can identify yourself for the court reporter when you're speaking. I'd like to go ahead and get entries of appearance. Can we start with the company, Missouri American?
Thank you, Judge. Dean Cooper from the law firm of Bryden, Swearingen and England, PC, P.O. Box 456, Jefferson City, Missouri 65102, appearing on behalf of Missouri American Water Company.
All right, and you have co-counsel with you as well? Mr. Luft?
Yes, Mr. Luft is on the line. Mr. Timothy Luft of Missouri American Water Company, 727 Craig Road, St. Louis, Mo. 63141.
Okay, thank you. Commission staff.
Thank you, Judge. Mark Johnson on behalf of the staff of the Missouri Public Service Commission. Our address is 200 Madison Street, P.O. Box 360, Jefferson City, Missouri 65102.
Thank you. And the Office of Public Counsel?
Good morning, Judge. Thank you. Caleb Hall appearing on behalf of the Office of Public Counsel. Our office is located at 200 Madison Street, Suite 650, Jefferson City, Missouri 65102.
And the City of Riverside?
Good morning, Your Honor. Brian Bear on behalf of the City of Riverside of the law firm Spencer Fain. Address is 304 East High Street, Jefferson City, Missouri 65101.
Thank you. The City of St. Joseph asked earlier to be excused, and I granted that. Midwest Energy Consumers Group.
Thank you, Your Honor. David Woodsmall on behalf of the Midwest Energy Consumers Group.
Missouri Industrial Energy Consumers. Right. I'm not seeing anyone present yet. She may be having issues, but we will proceed. All right, what we're going to do this morning is basically hear opening statements or information from each of the parties about the stipulation and agreement and open it up for commission questions. And I'd like to just begin in that same order that I just took entries of appearance. Let's begin with the company.
Thank you, Your Honor. May it please the commission. As stated before, Dean Cooper appearing on behalf of Missouri American Water Company. Also with me today and available to answer questions is Mr. Brian LeGrand, who is the Director of Rates and Regulatory Support for Missouri American. As you're aware, this case was initiated by Missouri American's filing of an application for an accounting authority order related to the extraordinary impacts of the COVID-19 emergency. In response, Missouri American established priorities across its organization, focusing on three areas: the safety of its customers and communities it serves, the care and safety of its employees and their families, and the execution of its preparedness plans so that Missouri American could continue to provide essential services and help its communities during this public health emergency. Beginning in March of 2020, the company began implementing measures to provide additional protections to customers and employees during the COVID-19 emergency. The company subsequently sought the accounting authority order requested herein in order to defer for consideration in its next general rate cases the financial impacts of these actions. The parties to this case have been largely understanding of the situation in which Missouri American found itself, and as a result of the discussions and negotiations amongst the parties, we were able to reach a non-unanimous stipulation and agreement, the agreement that's now before you. While not all parties are signatories to that agreement, those parties that are not signatories have not objected, and therefore the agreement may be treated as unanimous under the Commission's rules. The structure of the stipulation and agreement is very similar to the stipulation that the Commission discussed with Spire earlier this week, in which the Commission approved at yesterday's agenda meeting. The term of the deferral period begins March 1 of 2020 and runs through March 31st of 2021, with some potential for extension depending upon agreement of the parties and most critically, the order of the Commission. The stipulation provides that Missouri American may track and defer into a separate regulatory asset certain new and incremental operating and maintenance expenses specified within the stipulation. It's also permitted to defer increased bad debt expense beyond a certain threshold or in relation to a certain threshold specified in the stipulation. It's allowed to defer certain interest expense. It's allowed to defer late payment fees that have been waived. And there's also provision for deferral of certain reconnection charges and disconnection charges that have been waived during the period. The stipulation specifies that Missouri American will not seek carrying costs on the deferred balances in its currently pending rate case, and further says it will not seek carrying costs in a subsequent rate case for those items deferred beyond the true-up date in the pending rate case. The company agrees not to defer any lost revenues that are based upon reduced customer usage or volumetric charges due to the pandemic. The only items that might fit into lost revenues are those late payment fees, reconnection charges, and disconnection charges that are specified in paragraph 4 of the agreement. The company also has agreed to defer certain savings as an offset to these expenses, and those are specified in paragraph 7 of the stipulation. The company has agreed to report on a variety of items that are specified in the stipulation beginning a couple of weeks, 2 weeks, in fact, after any approval of the non-unanimous stipulation and agreement. The reporting is to be filed in EFIS and thus available to all those that would seek to learn from that reporting. The company will update the reporting on a quarterly basis until until the conclusion of the update or true-up period in the company's next general rate case. And quarterly reports are going to be filed within 45 days of the end of each quarter. There's a provision that requires the company to provide its accounting practices and procedures to the other parties. There is specified in the stipulation the fact that there is no future recovery agreed to within the stipulation. All questions regarding potential rate-making treatment are reserved for both the pending Missouri American rate case or a future rate case, depending upon timing of deferrals. And there is a provision related to the Evergy appeal. I think, again, the commission discussed this somewhat on Monday in the Spire stipulation presentation, but it revolves around the Sibley appeal that is still pending to some extent before the courts. Lastly, or not lastly, there's two more items, but the company has agreed in terms of customer support to make an additional contribution to its H2O Help for Others program. These are additional dollars above and beyond what has been contributed in the past to that program. Hopefully it will allow for additional resources to be utilized through a platform that's already in place and that people are already familiar with. And lastly, there is the provision that the company will cease any full credit external reporting of its customers for the duration of any approved AAO. MAWC would request that the company find and conclude that the non-unanimous stipulation and agreement is a reasonable resolution of the issues before the commission in this case, and ask that its terms be approved, and we are available for any questions that there may be.
Thank you, Mr. Cooper. Are there any commission questions for the company?
Yes, Judge, I have some questions.
Thank you, Mr. Chairman.
Thank you. First up, and this may be a question for you, Judge. As I look at this agreement, paragraph 3 references the city of Joseph instead of the city of St. Joseph. Is that something that needs to be fixed before we approve this?
I hadn't noticed that. Thank you for pointing that out, Mr. Chairman. I'm not sure that it isn't clear that it's the city of St. Joseph, but since there was a Josephville or something yesterday, I didn't realize that we had in the state. Perhaps the company could just submit something saying, clarifying that, and if any of the parties would have an objection to clarifying that that is the city of St. Joseph.
Okay. I just wanted to bring that up before we get into the more substantive questions. But
appreciate that.
Okay, so thank you, Mr. Cooper. In 4 sub B, where it talks about the increased bad debt expense, why was $2.6 million chosen for that number? Is that the level recognized in their current existing rates, or is that a different number? And you're muted, sir.
Sorry, Mr. Cooper. Go ahead. I unmuted you.
Okay. Chairman, that's what it That's what it intends to be. This is a situation where in the last rate case, the company's case was settled. So the company and staff arrived at, and the other parties obviously that signed on to the agreement, but primarily the company and staff arrived at this number as a fair representation of the bad debts that are currently included in the company's rates.
Okay, thank you. I would just add at this time too, instead of asking every party questions, if any party disagrees with anything that's said, please address it during your time. Next on C, where it looks at the interest rate as being LIBOR plus 80. Is that the interest rate being paid for the entire term of the loan?
Yes, Chairman. Although that changed after the first 6 months of the loan. So it actually, the interest rate being paid, the LIBOR plus 80 was one amount for the first 6 months, and then currently is actually a lower amount at this time.
Okay, thank you. Down in, I think 9. No, not 9. I'm sorry, 13. Will the company provide the commission copies of the applicable policies and procedures intended to govern how monthly deferral payments are to be calculated for each applicable category in the monthly reporting format?
Well, I would say yes, Chairman, that we certainly can do that.
Okay, thank you. And then in 14, the true-up cutoff for the pending case is the end of December 2020. Is that right?
That's correct.
Okay, so what type of deferred items would the company anticipate not being addressed in the pending case, which is WR-2020-0344, but instead being addressed in the subsequent rate case?
Mr. LeGrand, do you want to address that?
Sure. Sure. Yeah, thank you, Mr. Chairman. So the period after the true-up, any deferral continues beyond the true-up, or to the extent that the deferral period is extended.
I'm sorry. I just couldn't hear very well. Maybe just make sure everybody mutes while he's speaking.
Okay, sure. I'll start over. So any deferral that continues past the true-up in the rate case, so the period through March, and any to the extent the deferral period was extended by agreement of the parties with the approval of the commission, anything in that period I think would be deferred then for future rate case consideration.
Do you have any idea of what types of deferred items we were talking about, or is this just a blanket, everything could be in one or the other? Yeah,
well, no, I'm sorry. I believe that would be the same types of items being deferred here. So any incremental costs, the fees in a period where we've stopped collecting fees, netted with any savings. So I think the same costs would apply. The same items being deferred as described in this agreement would be the deferral items we'd be talking about.
Mr. LeGrand, would an example be some of the operating and maintenance expenses? Is it possible that some of that would continue beyond December 31st of this year?
Yes.
Thank you. And then again, just to clarify, and I know that you touched on this, Mr. Cooper, but number 15, as it relates to the Evergy appeal, just so we're clear, the only type of decision that would invalidate this stipend agreement is if the Supreme Court were to say that accounting authority orders across the board are not valid in Missouri. Is that correct?
That's consistent with my understanding. Yes, Chairman. Okay.
And then finally, in 16, where it talks about your additional contribution to the H2O program. Would those contributions from the company be tracked as a regulatory asset as part of this agreement?
Let me defer to Mr. LeGrand there.
Yeah, sure. Thank you. No, Mr. Chairman, these would be not part of the deferral. This would be a contribution made by the company that we would not be seeking recovery on.
Okay, thank you. Thank you, Judge. That's all of the questions that I have, and I would just ask if any party disagrees with any answer given that they would state so at the appropriate time. Thank you.
Thank you, Mr. Chairman. Are there any other commission questions? Not hearing any other commission questions. Let me double check really quick here. I just have a couple of other things here. So with the reporting that's agreed to in the stipulation and agreement, that's going to be filed in this case, is that correct?
That's correct, Your Honor.
Okay. And do you know how soon after a bill isn't paid that a customer is disconnected?
Yes, I can answer that, Judge. When a customer bill is issued, the due date is at least 21 days after the date of issuance, and then if a payment is not received within 5 days of that due date, then a notice is provided to the customer about disconnection. That the disconnection could occur after 10 days. So, probably 35-ish, 40 days after the bill is sent, if it's not paid, is when a customer could be disconnected.
Okay, and do you know how long after after disconnection or a bill isn't paid that gets written off as bad debt?
Yeah, it takes approximately 5 months from start to finish after it goes through a few different processes. And there are opportunities along the way for different interventions, be it the customer could set up a payment plan, or maybe there's an outside agency that intervenes on behalf of the customer to help pay the bill.
Okay, thank you very much. All right, then if there's nothing else for the company at this time, let's go ahead and go to commission staff.
Thank you, Judge. May it please the Commission. As I stated earlier, I'm Mark Johnson, appearing on behalf of the staff of the Missouri Public Service Commission. Today, I have with me staff members Nattel Dietrich, Mark Oligschlager, Kimberly Bolin, and Jim Bush. Together, we are able to answer any questions you may have. I will try to be very brief, as I believe Mr. Cooper did a good job of outlining the terms of the agreement. Staff believes this is a fair and reasonable resolution to the matters before the Commission. The COVID-19 pandemic is certainly an extraordinary event, the likes of which we haven't seen in our lifetimes and hopefully will not see again. The terms of this agreement, in staff's opinion, provide for the ability, or for the company's ability, to track certain new and incremental costs associated with the pandemic, with the offset of any additional savings that have been caused by the pandemic. In addition, staff views the reporting requirements agreed to be an important term of this agreement. Will provide regular identification of the costs, revenues, and savings as they're outlined in the agreement to all parties in the case and the Commission. Of note, staff would also point out that the company has agreed to not seek lost revenues associated with COVID-related reductions in usage. It has also agreed to not seek any carrying costs associated with deferred amounts at any period now or in the future. And in addition, as a result of the agreement, the company will contribute an additional $250,000 to its H2O Help to Others program, which is a program that provides through contributions from the company and from donations from its customers, supplemental assistance to Missouri Americans customers that have trouble with paying their bills. In all, staff believes the terms of this stipulation to be reasonable and requests that the commission approve it as drafted. Thank you.
Thank you, Mr. Johnson. Are there any commission questions for Mr. Johnson or staff? All right, I'm not hearing any commissioner questions. Let me check my list here. Mr. Johnson, do you know why the provisions that included to allow other costs and revenues not currently known, I think of paragraphs 4A and 7J. Do you know why that other costs were there? What would possibly be included there?
Sorry, I could not find the unmute button. It's my understanding those provisions are included in the agreement so as not to exclude any potential cost or savings items that, in the party's opinion, should also be included in the accounting order.
Okay. And will the possible later recovery of any bad debts written off be distinguished between COVID-19 and non-COVID, or is that a matter for rate making? Do you know?
Is your question in terms of whether the bad debt expense would be separately identified as related to COVID or not?
Yes.
It's my understanding that the bad debt expense will simply be a single cost item limited to the $2.6 million. However, Kimberly Boland may be able to better respond to that question.
Hey, Judge, this is Kim Boland. Trying to separate out what is a bad debt expense due to COVID and what isn't is very challenging. So I think that is why we included the limit. Part of the reason we included the limit on the amount of bad debt expense that could be included in this deferral.
Okay. All right. I don't think I have any other questions for staff. If there's nothing else, then we'll move on to public counsel. Thank you, Mr. Johnson.
Thank you, Judge, and may it please the Commission. Public counsel supports this stipulation for similar reasons why it supported the stipulation between the parties and Spire. The Commission will note that most of the operative language of this stipulation are substantially similar to this one. Whatever differences that exist are mostly due to the unique differences between a water utility and a gas utility. In response to some of the Commission's questions and concerns, I will note that there is no party that is wanting to refer to Josephville, Missouri, and so we regret the unfortunate typo. This stipulation does include boilerplate language that we are asking for this to be approved without revision. However, if the Commission were to make it clear in its order that it is reading the Joseph language to refer to St. Joseph, I don't believe any party in this docket is going to object to that. Like I touched on previously, we support this stipulation similar to the Spire one because instead of an expansive recording of possibly innumerable different cost categories and items within a deferral, we have specifically enumerated and limited costs and savings. We believe that is beneficial to both the public and the company. And I wish to actually We are grateful for the terms that were agreed to for Mock to contribute more money to its HTO help program. This is above and beyond what Mock has done previously for customers. So the company is not resting on past laurels. It is actively contributing more in response to COVID-19. On the call with me this morning is Dr. Jeff Mark, and we are both available for questions.
Okay, thank you. Are there any questions for public counsel from the commission? Right, I'm not hearing any, and I don't believe I have any. Thank you, Mr. Hall. Is there any opening from or statements from the city of Riverside?
Yes, Your Honor. I'll be very brief. May it please the commission. City of Riverside would simply echo the statements that have already been made by staff and by the public counsel. One of the challenges that the commission is confronting with the COVID-19 crisis is the myriad amount of unknowns in the policymaking realm. And we think that this agreement allows the flexibility for the utility to address those unknowns while putting in place some necessary guide rails that will allow for a thoughtful way of dealing with the crisis going forward. And so we would echo the support of the previous positions. Thank you.
Thank you, Mr. Baer. Are there any commission questions for the city of Riverside? See no questions. Thank you. We will move on then. Is there anything from Midwest Energy Consumers Group?
Good morning, Your Honor. No, I'll be very brief. I think Mr. Cooper did a fine job going through the various provisions. I don't have anything to add to the answers that were provided by two commissioner questions, and I'd simply urge the commission to approve the stipulation.
Thank you, Mr. Woodsmall. Are there any questions for the Midwest Energy Consumers Group? Not hearing any commissioner questions. Did anyone join us for Missouri Industrial Energy Consumers? Right, I don't believe so. Was there anything else from the commission that didn't get asked of any of the parties? Right, I'm not seeing anything. Did any of the parties have anything additional that they wanted to add on the record? Okay, looks like that will conclude then our hearing. I appreciate you all being here today, and we can go off the record.